Hi everyone, welcome. I'm Sarah with the Shelter Island Public Library. I'm here with Terry Lucas and Mara Zonderman for our next chapter on talking the Bill of Rights. And tonight they're going to be discussing amendments 7 and 8. Next, as a reminder, next episode is going to be Thursday, September 17th, Constitution Day. And they'll be doing amendments 9, 10, and then a wrap up. Before we get started, I just wanted to thank our East End Public Libraries for joining us on this one. I'd like to thank the Westhampton Free Library, Amagansett, Cutchogue, New Suffolk, East Hampton, Floyd Memorial, Hampton Bays, Mattatuck Laurel, New Suffolk, Quogue, Southold, Port Jefferson, and Riverhead. And if you guys have any questions, please feel free to type them in the chat during the program or use the Q&A function, and we'll get to them towards the end. And with that, I'm going to turn it over to you guys.
Great. Well, we're going to start off with the Seventh Amendment. So I think we need to
Yep.
share the screen.
Yep.
And do I need to make you a co-host to do that, Mara, or can you just share the
Uh,
screen?
I think I can just do it.
Okay.
Oh, no, I need to be a.
So
Oh,
actually, Sarah, you're in there as a host. Can you make Mara co-host,
yep.
please, so she can share her
He is
screen?
already on it.
There we go. She's so good.
All right. Hopefully everybody can now see the screen.
Perfect. Okay, so as usual, we're going to start off with a little bit of history, and then Mara will get into the cases. So, um, Seventh Amendment. If we could go to the Seventh Amendment slide, which I think is next. There we go. In suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. So the Seventh Amendment was ratified on December 15th, 1791, as were quite a few of our amendments, and it's pretty clear cut. Despite the fact it has not been incorporated by the 14th Amendment, almost every state provides for jury trials in civil cases in its constitution. The clause dealing with overturning a jury's decision applies to federal cases, state cases involving federal law, and review of state cases by federal courts. So the next slide, please. So the minimum dollar amount to require jury trial has not been changed over all of these years, despite inflation since the 18th century. The $20 noted in 1890 would be worth roughly $732 today. So it's a little bit more, but they're sticking with the $20. Once again, the amendment traces its roots back to English common law. And during our last session, we talked about the influence of William Blackstone on the framers of the Constitution. We could do the next one. And Blackstone called the right to a jury trial the glory of the English law. The trial by jury ever has been, and I trust ever will be, looked upon as the glory of the English law. Excuse me just a sec. My light likes to go off in my office, so sorry about that. Just a little break. The right to civil trial was really important during the colonial period while colonists were resisting the King of England's laws and decrees. And despite this, the right to a civil jury trial was not included in the original draft of the Constitution. The right to a civil jury trial was raised by Hugh Williamson of North Carolina during the Constitutional Convention. I'm going to go on to the next slide because I'm going to be catching up to it. While there was some support, the thought was that states differed widely with respect to civil trials, and therefore it would be impossible to draft a provision that could encompass all the differences. Another delegate made a motion to include the right to a civil trial, but the motion was defeated. So this omission led to the concerns that might keep the Constitution from being ratified. Another concern was that the recognition of only criminal jury trials at the Constitution would result in the abolishment of civil trials. There was a lot of this when they were talking about ratifying the Constitution. Is the language, if we don't include language, is it excluded? How is it going to be thought about in the future? So it's one of those things that they really, really debated a lot of different items that were either mentioned or not mentioned, and what would it mean if you didn't mention, or what would it mean if you did mention them? So, an anti federalist tract stated that jury trials were the surest barrier against arbitrary power, and that judges unencumbered by juries have been ever found much better friends to the government than to people. So, they're very, once again, concerned about that very strong central government. So, this is anti federalist Mercy Otis Warren, who may be the only woman I actually ever got to show you on this entire thing so far. So, and she wrote that trial by jury in civil causes has the learned Judge Blackstone observes, has been coeval with the first rudiments of civil government, that property, liberty, and life depend on maintaining in its legal force the constitutional trial by jury. So this really was quite the debate. So James Madison included the right to a civil trial in the list of amendments he presented to the first Congress. There's actually weirdly, no evidence of discussion of the text or debate about the inclusion. So I think after discussing it for so long, they finally said, yeah, this is what we want. So once it became part of the Bill of Rights, this amendment had to be interpreted by the Supreme Court. And the Supreme Court has interpreted the phrase suits at common law under the amendment as preserving the right of trial by jury in civil cases as it existed under the English common law when the amendment was adopted. This means the amendment does not guarantee trial by jury in cases under admiralty or maritime law and in other proceedings historically tried by a court instead of a jury. Nor does it reach statutory proceedings unknown to the common law concerning the enforcement of statutory public rights created by Congress. It's a little complicated, but to clarify a little, matters that were tried by a jury in England in 1791 should be tried by a jury today. Matters that fall under equity and admiralty and maritime, which were tried by a judge in England in 1791, should be tried the same today. So when new rights and remedies are created, the right of action should be analogized to its historical counterpart, which sometimes is a little bit of a gymnastics event, but they try to determine where it fits, whether they have a right of a jury trial or whether Congress has expressly prescribed the mode of trial. So this might be just about as clear as mud. So I'm going to kick it over to Mara to try to explain it a little bit further.
Okay. So thanks for giving me the mud. So the Seventh Amendment, as Terry said, is one of the few parts of the Bill of Rights that is not incorporated to apply to the states, largely because at the time the Bill of Rights was being ratified, all 13 original states had something very similar, if not identical, to this preservation of jury trials. And even today, 47 of the 50 states have this preserved in their own constitutions. The states that don't are Colorado, Louisiana, and Wyoming. Not really sure why, but they have different rules. Louisiana has different rules for everything. So, as Terry said, this came about as a direct contrast to cases that would have been tried in Admiralty Court or Maritime Court. And those of you who were with us back in January, remember that in the Declaration of Independence, the King George was called out for, among other things, depriving us in many cases of the benefits of trial by jury, which was a reference to the Sugar Act of 1764 and the Stamp Act of 1765, which transferred certain kinds of cases from colonial courts to juryless vice admiralty courts. So as a result, common law refers broadly to the types of claims that would have been brought before a jury, as Terry said. And the court has been clear that the Seventh Amendment doesn't apply only to civil matters that would have been tried in a common law court in 1791, but to anything that is of the type of case that would have been tried. So we're not, in contrast to some other constitutional interpretation, we're not saying it if it wasn't applied then, it's not applied now. We're looking at a group of cases, a style of cases, if you will. And all of those would be seen to be covered at the federal level under the Seventh Amendment. So there's two primary parts to the Seventh Amendment. The first is the Preservation Clause. If you remember the text of the amendment, the right of trial by jury shall be preserved. So the Preservation Clause, there are two factors. First, we ask whether the action is akin to a common law cause of action, right? Is it the kind of case that would have been considered common law? And then also whether the remedy is of the type that can only be obtained in a court of law. So, as an example, there's a case from 1987. And in that case, the government sued a real estate developer for dumping fill on wetlands on Chincoteague Island in Virginia in violation of the Clean Water Act. Having grown up in Maryland, we always were hearing about the horses on Chincoteague and Assateague, and of course you may have read the book Misty of Chincoteague. So it's protected by the Clean Water Act. They dumped their fill in the wetlands, and the government sued the real estate developer. So the Clean Water Act imposes fines that go beyond the cost to remedy the harm, and also any profit that may have been gained by violating the statute. The Clean Water Act allows a fine of up to $10,000 per day of violation, as the court said, clearly indicating Congress's intention that the penalty be a punishment and a deterrent. So the act is set up so that violators don't just have to pay back the cost of fixing it. They don't have to pay back what they made by breaking it. They also have this fairly substantial $10,000 per day fine. And the court said that only civil trials with the possibility of punitive remedies, in this case the $10,000 a day fine, trigger the Seventh Amendment guarantee of a jury. To put it somewhat simplistically, as we discussed last time with criminal trials, just as a jury trial is required in criminal charges where the defendant is at risk of losing their life or liberty, so too is a jury required at a civil trial where the defendant is at risk of losing their property. And again, the loss of property isn't just paying back what you owe, it's that additional punitive fine on top of it. The other part of the Seventh Amendment is the re-examination clause. Right, that's the second part of the amendment. No fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. And the Supreme Court has not spent a lot of time on this one. Basically, it prevents federal appellate judges from overturning jury verdicts from lower federal courts or state courts on questions of fact. So the court is very firm in saying the trial courts are the ones that are hearing the testimony, that have the ability to ask the questions. And if they have determined what a fact is in this case, federal appellate judges cannot overturn it. They can say the law was applied incorrectly in any number of ways, but when it comes to fact, the trial judges are, the decision of the trial courts are sacrosanct. And that is basically all there is to say about the Seventh Amendment. So, Terry, are you ready to move on to the Eighth Amendment? You're muted, though.
Sorry about that. Okay.
And I think our slides got a little out of order. Do you need me to scooch back
Let's
some?
see. No, I think I'm good.
Okay.
We'll find out as we go along here.
Okay.
Let's see that. Well, let me see the next one and see. Okay, there we go. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So these clauses on the surface seem pretty straightforward. In a strange way, again, the simplicity of the amendment has led to the interpretation of the clauses being a little more complicated. Again, it may seem like what was simple then or understood then, as time goes on, understandings change about how we look at things, which has happened all the way along. But with something like this, it's a little bit different. So we'll start with excessive bail. I think we should have the 1689 Bill of Rights next, maybe in the next slide. Let's see. Oh, there we go. There it is. It's just a, so you can see what it looked like. So the excessive bail clause comes from the 1689 English Bill of Rights Act. It is unclear whether this clause gives a right to bail in all cases or to provide that where bail is allowed, it may not be excessive. There's no evidence of the intent of the framers in the amendment, so this amendment has been interpreted in different ways over the years. So for nearly 6 centuries, the Statute of Westminster, which was passed in 1275, was the law of England with respect to bail. That statute set forth the offenses that were bailable and those that were not. So I spent a little time trying to find that list. And after I did find bits and pieces of the list, I understood why I could not find the list. Basically, lesser offenses were bailable and greater offenses were not. So I'm going to read you a little bit of the language, and bear with me, but this is what was understood for very many years. But such as be indicted of larceny by inquest taken before sheriffs or bailiffs by their office, or of light suspicion, or for petty larceny that amounteth not above the value of blank, if they were not guilty of some other larceny aforetime, or guilty of receipt of felons, or of commandment or force, or of aid in felony done, or guilty of some other trespass for which one ought not to lose life nor member, and a man appealed by a prover after the death of the prover, if he be no common thief, nor defamed, shall from henceforth be let out by sufficient surety, whereof the sheriff will be answerable, and that without giving aught of their goods. So basically, again, it's if you didn't do some really, really bad things, if you didn't kill somebody, maim somebody, hurt somebody, or do a number of things together, you could get some bail. So in 1628, one of the reasons the Petition of Rights was enacted was that the king was denying bail and putting people in prison. So judges who didn't want to comply with the Petition of Rights and the Habeas Corpus Act of 1679 got around it by setting really high bails. So that was a way to basically set the high bails, not address the problem, not have the trial take place, and someone was being punished because they couldn't get out of jail. And then that, this was addressed by the 1689 Bill of Rights in the language that is fairly hard to read. So a complaint set forth in that Bill of Rights stated, an excessive bail hath been required of persons committed in criminal cases to elude the benefit of the laws made for the liberties of subjects. So that's where this became so important. So then we're going to come back over to the colonies. We're coming back over to the Congress looking at this amendment. So this left the question of whether Congress, in passing the amendment, gave the right to bail in all cases again, or if it silently incorporated the bailable offenses set forth in the old Statute of Westminster. So to make it even more ambiguous, if it's not ambiguous enough, the Massachusetts Body of Liberties in 1641 guaranteed bail to all accused person except those charged with a capital crime or contempt in or open court. So several state constitutions copied this clause in their state constitutions. It was also included in the Northwest Ordinance of 1787 and Judiciary Acts of 1789. So once again, clear as mud. Sorry, Mara. So the second part of this is cruel and unusual punishment. So in the English Bill of Rights of 1689, cruel and unusual punishments were forbidden. The Declaration of Rights in Virginia in 1776 also incorporated this clause. This is a case where the definition of the meaning of cruel and unusual punishment is open to interpretation, and what might have seemed cruel and unusual to us might not have seemed that way in 1776. So it was, I think as time has come on, cruel and unusual's meaning has changed. So the staunch anti-federalist Patrick Henry was very concerned about a lack of a cruel and unusual provision in the Constitution. He said, Congress may introduce the practice of France, Spain, and Germany of torturing to extort a confession of the crime. They will tell you there is such a necessity of strengthening the arm of government that they must extort confession by torture in order to punish with still more relentless severity. We're then lost and undone. So he really didn't want this to be happening in this new country. So later, when the Congress was considering this amendment, Samuel Livermore of New Hampshire here said, the clause seems to express a great deal of humanity, on which account I have no objection to it, but as it seems to have no meaning in it, I do not think it necessary. What is meant by the term excessive bail? Who are to be the judges? What is understood by excessive fines? It lies within the court to determine. No cruel and unusual punishment is to be inflicted. It is sometimes necessary to hang a man. Villains often deserve whipping and perhaps having their ears cut off. But whoops, lost my light again. Someday we will be out of the trailer, everyone. But are we in future to be prevented from inflicting these punishments because they are cruel? If a more lenient mode of correcting vice and deterring others from the commission of it could be invented, it would be very prudent in the legislator to adopt it. But until we have some security that this will be done, we ought not to be restrained from making necessary laws by any declaration of this kind. So what I got from that is you don't want to cross Samuel Livermore because he will hang you, cut your ears off, or whip you. So again, this is one of those things where at that time maybe not considered to be the worst thing in the world, but things have changed. So once again, Mara, leaving you with the tough stuff.
Hey, gee, thanks. Okay, let me flip through this. Okay. So we did this. Sorry, our slides are a little out of order. Okay. So as Terry mentioned, there are three parts to the Eighth Amendment: excessive bail, excessive fines, and cruel and unusual punishment. So to start off, excessive bail. And incidentally, all three of those parts have been interpreted to be incorporated in to apply to the states. So the same kinds of rules apply. So excessive bail doesn't come up a ton, but in 1984, yes, 1984, Congress passed the Bail Reform Act. The Bail Reform Act requires courts to detain prior to trial arrestees charged with certain serious felonies if the government demonstrates by clear and convincing evidence after an adversarial hearing. So you can hear there's a lot of clauses in there. They're making sure that all these boxes have to be checked before somebody can be held without bail. So after an adversarial hearing, that no release conditions will reasonably assure the safety of any other person in the community. The arrestees have a number of procedural rights at this detention hearing, including the right to request counsel, to testify, to present witnesses, to proffer evidence, and to cross-examine other witnesses. The Act goes on to specify the factors that need to be considered in making the detention decision, including the nature and seriousness of the charges, the substantiality of the government's evidence, and the arrestee's background and characteristics, and the nature and seriousness of the danger posed by their release. So, again, quite a lot of things the government has to prove before a decision to hold someone without bail will be upheld. So what constitutes something that would check off all these boxes? Well, in 1987, so just a few years, these two gentlemen were arrested. They are the boss and captain the boss and captain of the Genovese crime family of La Cosa Nostra, and were charged with 29 counts alleging various RICO violations, mail and wire fraud offenses, extortion, and various criminal gambling violations. It was a big deal. So the court started off by saying, and so they were determined that they could be held without bail, and they challenged that, saying it was a violation of their Eighth Amendment rights. And the court started off by saying that nothing in the Eighth Amendment requires that there be bail at all, right? So it's only if you're going to have bail, it can't be excessive under the circumstances. But they went on to say that. They said if the only asserted interest is to guarantee that the accused will stand trial and submit to sentence if found guilty, then bail must be set by a court at a sum designed to ensure that goal and no more. Okay, so again, if you watch Law and Order, they'll talk about flight risk. Obviously, our penguin does not appreciate that. Does the defendant have strong ties to the community? All of those kinds of things. So bail should be proportional to the defendant's financial means and likelihood of flight, but a judge can take into account other compelling state interests, including public safety. And to go back to these lovely gentlemen who need to hire a better photographer, the public safety obviously was of paramount importance. And the court basically said, there's no way if we let them out that they're going to stick around or not go back to their previous ways, so they can be held without bail with no violation of their Eighth Amendment rights. So moving on, excessive fines. Generally speaking, fines are interpreted to have the same meaning as when the Eighth Amendment was adopted. In other words, it's a payment to the sovereign or government as punishment for some offense. However, it can also be applied in civil forfeiture cases, since the amendment is not limited. There's nothing in the language of the amendment talking about criminal cases. And the relevant constitutional test is whether the law being applied is punishment. So just like we saw with the Seventh Amendment, very similar to the Eighth Amendment, if the same kinds of property rights are at issue, then this clause will apply either way. And basically, there's not much to say about it. The rule is proportionality. They've declined to set a test for proportionality, and instead said that a fine must not be grossly disproportional to the offense, which just makes me think of Justice Potter's thoughts on obscenity, right? He knows it when he sees it. There was there have been a few cases where they have said, yes, this is proportional, no, this isn't proportional. One of them came just not too long ago in 2019, where a defendant's car was used to transport heroin. And the state wanted to seize the car as being part of the crime, and to pay for the fines that the defendant accrued. The maximum statutory fine was $10,000. The car was valued at $42,000. And the court said that is disproportionate. Just because the car was used in the commission of a crime does not mean that something that's 4 times what the state is allowed to collect can be collected as a fine. So, proportionality. And then we get into cruel and unusual punishment. Again, proportionality is the rule of the day. The court's been a little clearer about what that means in this case. The sentence has to take into account the gravity of the offense and the harshness of the penalty. They have to think about sentences imposed on other criminals in the same jurisdiction, as well as sentences imposed for commission of the same crime in other jurisdictions. That's how we're going to figure out, is this proportional? Basically, the punishment should fit the crime, right? And the court asks, does it? Questions about proportionality tend to arise when we start talking about 3 strikes laws. right? Where harsher punishments are established for repeat offenders, even if the crime in question is relatively minor. And as we've discussed, that's because the court understands that the government has an interest in reducing recidivism. And if it's proved that a minor punishment for a minor crime is not effective in deterring, then the court will allow harsher punishments. There are also questions about how proportionality applies to juvenile offenders. I don't know the answers to these. It's still a very gray area in the law. I just wanted to put out there that those are the questions that we're considering when we talk about proportionality. Another aspect of cruel and unusual punishment is conditions of confinement, right? We all know that you can be put in jail, but what is required of the warden or the prison system once you're there? Generally speaking, courts won't find an Eighth Amendment violation unless conditions are imposed under a system of deliberate indifference on the part of prison administrators to the rights of their wards. In specific cases, including cases where the question is that suppressing a disturbance by inmates, the court will ask whether there was a good faith effort to restore or maintain order. Or the flip side of that, whether a malicious or sadistic state of mind led to the conditions. Absent deliberate indifference, absent a malicious and sadistic state of mind, the court will say these conditions are fine. And then, of course, the big question about the Eighth Amendment is the death penalty. So as far back as 1890, yes, 1890, the court has said punishments are cruel when they involve torture or a lingering death, but the punishment of death is not cruel within the meaning of that word as used in the Constitution. It implies there something inhuman and barbarous, something more than the mere extinguishment of life. The primary case on the death penalty came much, much later. In fact, in 1972, is a case called Furman v. Georgia. And the court essentially said the death penalty is only unconstitutional under the Eighth Amendment when it is imposed in an arbitrary and capricious manner that leads to discriminatory results. So there's nothing wrong with it on the face of it, unless the way it's applied becomes problematic. So in 1972, the New York Times ran this headline because essentially what happened then, there was a moratorium on the death penalty. I also want to point out that on Friday, June 30th, 1972, the New York Times cost 15 cents, which is not what it costs today. So there was a moratorium, as basically every state had to revisit every state that had the death penalty had to revisit their statutes to do everything they could to make sure that the death penalty was applied in a fair and non-discriminatory way. The court said it would seem to be incontestable that the death penalty inflicted on one defendant is unusual if it discriminates against him by reason of his race, religion, wealth, social position, or class, or if it is imposed under a procedure that gives room for the play of such prejudices. So the states went back to their books. Ideally, they all came up with statutes that were not discriminatory in any way. We know that's not actually possible, but in post-Furman, what does the court say is required for a state death penalty to be non-discriminatory? And there are, I think I have four factors. So after Furman, the court reiterated that the death penalty itself is not in violation of the Eighth Amendment. And part of the reason it said this is because 35 states reenacted a death penalty statute after Furman, indicating in the court's words that there was still a social consensus in favor of the death penalty, and so it shouldn't be considered cruel and unusual by the standards of modern society. However, state laws cannot mandate the death penalty for any class of offenses, and building on Furman's rule that the death penalty cannot be imposed in an arbitrary and capricious manner, the jury must be given standards to govern its exercise of discretion and be given the opportunity to evaluate both the circumstances of the offense and the character and propensities of the accused. To prevent jury prejudice on the issue of guilt, there must be a separate proceeding after conviction at which evidence relevant to the sentence, mitigating and aggravating, be presented. There must be special forms of appellate review provided not only of the conviction, but of the sentence to ascertain that the sentence was fairly imposed, both in light of the facts of the individual case and by comparison with the penalties imposed in similar cases. Now, in 1984, this particular factor was determined not to be constitutionally required, but the court suggested that this type of proportionality review is one means by which a state may safeguard against arbitrarily imposed death sentences. And lastly, the death penalty cannot be imposed when a judge, rather than a jury, makes any factual findings as to whether the aggravating circumstances that allow for imposition of a death sentence are present. So you can see both in the first factor and then the last factor, this has to come from a jury of your peers, as we've discussed previously. The state can't make it an absolute for any type of crime. And a judge can't be the one to determine whether the facts exist that allow for the imposition of this additional crime. Barring any of these things, according to the court, the death penalty can be applied. Now, of course, there are a couple of other considerations. The court did have more to say about bias in 1987. The court said that it is insufficient to prove that, statistically speaking, the death penalty is applied more frequently in cases when a white person is murdered by a person of color, but the defendant has to prove that there was actual discriminatory intent or application in their particular case, which obviously is very, very hard to do. There are studies that have proved that there is discriminatory application, but the court has said that is not sufficient. You have to prove that it was discriminatory in this case. The other aspect of this that the court has looked at is the method of execution that is used. And basically, the court sort of, as they do sometimes, punted this one and said that methods that can be employed in carrying out death sentences, the only limit on that is that they made up this word, super add terror, pain, or disgrace to the death penalty. Other than that, anything goes. So on that lovely note, we'll move into questions. Before we do that, as Sarah said at the beginning, our next session is Thursday, September 17th, Thursday because that is Constitution Day, where we will discuss the 9th and 10th Amendments, and then sort of wrap all this up. So I see that there are a few questions. Sarah, can you, I'll stop sharing my screen, and we can move into questions.
Absolutely. I didn't see any questions in the chat, but if anyone has any questions they'd like to type, they are free to do so. You can also use the Q&A feature if you haven't already. We have a question from Sam. What would Blackstone think, notwithstanding his pithy quote at the beginning of your presentation, of the law passed by a slim majority in the British House of Commons to scrap jury trials for criminal matters, which could result in sentences of 3 or fewer years? There's also a link provided
Thank
Um,
you, Sam.
yeah.
I
Very in
think
depth. Very
that
good.
I think that Blackstone would be horrified because he kind of judged from up on high. I don't think that he actually ever had to think too much about the application of his beliefs in real life. So I don't know what I personally think about it, but I think Blackstone would have felt that it was going against everything that the beauty of British law applies to and the glory of British law applies to. That's, it's just reading his mind from many years ago.
As we do.
Yes, we do.
For those of you who have not tuned in previously, Sam is my husband, also a lawyer, and an Anglophile. So after when I saw that question, I punted it back to him. I was like, "You tell me, what would Blackstone think?" And he answered his own question, just for if anybody else is curious. He said that it's a dangerous development that can lead to erroneous and biased verdicts when the trier of fact and the trier of law are the same person. The bias of that sole person is too powerful, is what he imagines. His reading of Blackstone's mind from several centuries later. So thank you,
Fair
Sam,
enough.
for raising that thought-provoking question and for helping us answer it.
Here you go.
With that thought-provoking question, I have my favorite question of the night, which is how much hay would constitute excessive bail? Yep,
Ah.
that's a good one. That's pretty good. Okay, but we
you
do have a
got you gotta
serious.
love a pun, right? You gotta love a
I'm
pun.
into it. I'm always into it. So I do have a question from James. Why has the Supreme Court held that some, but not all of the Bill of Rights apply to the states?
That's a good question.
It is a good
Um,
question.
and it has to do, I think, with um, when it comes to this, they look at what was the intent in this case of the 14th Amendment. Remember, all incorporation comes through the 14th Amendment. And we could do a whole another set of sessions um, just on the 14th Amendment and incorporation. But in some cases, it's simply that a case hasn't come up, right? You need a case from the state to go to the Supreme Court in order for the court to say this applies to the state, right? So there's that. Um,
I
and
think in case of bail, there's also the history of it. I mean, I think all of this, you look back at the history and certain things kind of are more open to being incorporated to the states, and certain ones seem to have um, just a different relationship to the state, if that's not too amorphous of a concept. Because again, we're always looking back at the history. Why were they doing this? Why did how did this come about? Why did this come about? How do we interpret it given the fact that we're, what's the semi-sesquicentennial, 250 years past all of this, um, how do we interpret something that was talked about so long ago, and whether things should fit in with the state or not? It's just, I think it's tough, and I do think that they need to have a case. It's kind of often, as we've talked about in censorship, we talked about, to just kind of harken back to something else we talked about. You have to have that person or persons that are willing to get themselves into that situation and put themselves into that situation to have this question of the law answered. And it just may have not become important enough for anybody to be willing to take it on.
yeah, the court is very strict with itself about only taking cases that are brought to it and that it is within their purview to decide. Um, and I think, I mean, we're almost done uh, with the Bill of Rights, and I mean, what is it, three or four clauses that don't apply to the states?
Mm-hmm.
So for the most part, the court has said no, if it applies to the federal government, it applies to
To
the
the
state
states.
as
Yeah.
well. Yeah.
Yeah. Yeah. And I guess we could we'll probably talk about this more in the wrap up, but I'm kind of also thinking as we go along with the Bill of Rights, it does seem to be winnowing down onto it starts with these big ideas and then kind of gets down to detaily things that I can hear somebody saying, I won't sign this constitution, we won't ratify this constitution unless this is addressed
Mhm.
or that is addressed.
Mhm.
And then once that's addressed, how relevant is it as we go forward,
Mhm.
so which I
Yeah,
think
that
we'll understand when we get to 9 and 10 next month, that it was kind of like, well, where did these come from? So it's
yeah,
it's it's kind of an interesting thing. So um,
yeah, definitely 9 and 10 sort of, what was the thought process there?
what was the thinking here? And it
Yeah.
is, I mean, it's fun to think about what were they thinking,
Hmm.
how were they living that this
Hmm.
stuff was so important,
Hmm.
what kind of experience had they had with the king that made them feel that we needed to say these things in order to protect ourselves, because they were just so many, the anti-federalists were so frightened of a strong central government and what could happen if you let a government have too much power.
Yeah.
So
Sarah, I'm getting a note that the chat is actually disabled. Um,
Oh, okay.
I don't, somebody clicked
could
a
probably
button.
still go into the Q&A
The
though if
Q&A,
you want
yeah.
to.
So,
Yeah.
if
If
there
you
are any other questions, while we figure out what that's about, I'm just looking at a screenshot that was just sent to me. Um, but yeah, the Q&A is still available. Or you can raise your hand, if you have any other questions. Um,
Sorry, I'm working on getting the chat up and functioning. It's just always moved around in a different location on
yeah.
Zoom. So give me 1 second.
So do
In the
you,
Q&A, we did get a thank you from the Cutchogue New Suffolk library, and we got a thanks from James.
yeah, I think we got down to cruel and unusual punishment, and then there's so much of that comes to interpretation again. We have back in the day, it's you could have your ears cut off, and sometimes some people thought that was a necessary and not cruel or unusual punishment, whereas today it would be considered very much a cruel and unusual punishment. So again, we always have to look at the course of time and what is appropriate, what ages they used to basically find that you were of an age that you could be punished, and that now you would not be punished, or you might be punished but in a juvenile sense.
Mhm.
So life has changed, and so as life has changed, the meaning of these have changed as well. So um anyways,
Yeah.
Okay, we've
I
got
will.
a couple. Oh, sorry, we've got a couple in the Q&A. Do you want me to
oh
read
good.
those off?
Yeah,
Okay.
please.
We've got our first degree murder suspects typically held without bail.
I I could not tell you, to be perfectly honest. I think it depends, as we saw, there's a whole list of things that have to be considered.
Are they a
So,
flight risk? Are
right.
they this is where the inequity comes around. Okay, so we're going to put an ankle bracelet on you because you can live at your home and
Hmm.
still have food and still do what you need to do, and maybe we even let you go to work. And so it is. I think it kind of depends on the circumstances always, but also kind of there. I do think inequity does come into play with this a lot. So
Absolutely. But yeah, I mean, what kind of resources, if you have a lot of resources that would enable you to flee the country, that's sort of the flip side of that.
yeah, yeah, that's true. Yeah.
But yeah, I think um I did not see anything that indicated that there was any usual anything for any type of crime, basically. It really comes down to, um, as they would say, a totality of the circumstances.
And we have another question that sort of follows up on that. Christina asked, I'm curious what the standard is now for determining cruel and unusual punishment.
So, as the court has thought about this, they refer, um, a lot to this question of a maturing society. They do not say what that means. The general idea, I think, is that as we mature as a society, things like cutting off ears, becomes thought to be cruel and unusual. I don't think there is no societal consensus on what is cruel and unusual punishment, right? I mean, there are people who think the death penalty is absolutely okay, and there are people who think the death penalty is absolutely not okay. And the court looks to that, allegedly, to determine what is considered cruel and unusual. They, as with many things, they don't tend to say this yes and this no. It's what do the people think? And they, if the people are electing legislators who are going to keep enacting death penalty rules, then the Supreme Court is going to look at that and say, well, society is still saying this is okay, and if they say it's okay, then we say it's okay. It's a very unsatisfactory answer.
And now these days, it's like it's being put in solitary, considered cruel and unusual punishment. Right. Of course, 20 years ago, that would probably not have been considered cruel and unusual punishment. We kind of know more about how isolation can mess with your mind, basically, and so then that's the consideration. Is this something that should be happening? Is it not something that should be happening? And as we learn more about human beings and their behavior, things will probably change. If we look at prisons as a punishment versus a place that people can learn to be better people, that may come along as well. So it's just well, I think Ms. Mara's right. It's society, and how is society looking at these things these days? And is there a consensus over the whole country? And I would say, no, there's no consensus over the whole country about anything, much less what's cruel and unusual punishment. So, yeah.
Okay. I'm not seeing any more questions in the Q&A, and it looks like there's nothing in the chat.
Okay. Well, we look forward to seeing you on Constitution Day.
It's my favorite day of the year.
How do we
Looking
celebrate?
forward to it.
And don't forget to check on YouTube to see if you've missed any of these. You can jump on and you can see where we were with the first 8 amendments now, and we'll wrap it up with 9 and 10 in about a month.
Yeah, and feel free, if you do have a chance to go back and look at some of the previous recordings, in the wrap up, bring up some of those questions that you raised, because we are gonna dip into all 10 amendments.
Yes.
So
okay. Thanks, everyone.
Thanks, everyone.
Thank you so much.
Have a good night.
Good night.
Have a good night.